So I am normally in Harlem in New York, and I would say good afternoon, but I find myself in Los Angeles in the Pacific time zone. So I do have some coffee, and I will wish you all good morning if any of you are also on the left coast. It is a pleasure to be here virtually with you and in conversation with you. And I really hope that we can treat this just shy of 1 hour together as somewhat of a conversation. I do have a prepared presentation, but I invite you to interject, to interrupt, unmute yourself to ask a question, but also know that I will reserve time for question and answer at the end. I know Andy will help me out with that. While my slides are open and activated, I can only see a small fraction of folks. And so that's why I ask that you just interrupt and interject and unmute yourself, because otherwise I can't see if you're gesturing. So today I'll be speaking to you about Black on Black representation. It's an examination of racial congruency in indigent defense. And I want to tell you how I came up with that topic, that research, that area of research, and where I at least want to go with my research moving forward. So much about this paper, this project, is a reflection of my practice. So I am relatively new to academia. I'm officially starting as an assistant professor at Brooklyn Law this summer, where I'll be teaching evidence, crim pro, and also criminal law. Prior to that, I served 2 years as a practitioner in residence at Columbia Law School. And it was during that time that I wrote this piece. And it was my job talk paper. So any of you that are navigating that process or have navigated, just imagine talking about these issues with, a very diverse sort of faculty. I got some interesting questions, but it was really a pleasure and a privilege to be able to share this during that process. But prior to Columbia, I spent over a decade in practice, first as a federal public, assistant federal public defender in a capital habeas unit in Nashville, Tennessee. I was there for 8 years. And then as senior counsel at the NAACP Legal Defense and Educational Fund, known as LDF. And I primarily worked on capital cases in post-conviction, both at the state level and the federal level. Let's see. There we go. So a little bit of an overview. You heard about my relevant background, and so I'll get into my approach to the research. I want to situate my proposal, what I put forth in this paper within the existing scholarship. I want to be very clear about the intervention that I'm suggesting, and then also mention the caveats. And so I know, even from reading the abstract, and those of you that were able to complete the paper, maybe my mother's the only one out there, that you have, and you noted, some limitations, some caveats, some hesitation, perhaps, as you read the paper. I do want to explore also this history of not just indigent defense, but the right to counsel of choice. And if you're anything like me, you never really heard about and maybe didn't even consider it in your practice, those of you that are practitioners, or even as a scholar. I found that Stephen Schulhofer at NYU, who was actually my crim pro professor, was one of the only people to repeatedly write about the right to counsel of choice. And I want to talk about some of the present day implications if we did extend this to low income defendants. So you heard a little bit about my background. We've got, LDF's logo on the right. Those of you that have ever been in Nashville, that's where the Federal Public Defender's Office is, located across the street from the Federal District Court on Broadway, just a few blocks away from all the honky tonks. And then Morgan & Morgan is a law firm that, paid for all the signage outside, but it's where the FPD is located. And I don't mean to be glib or make light of capital punishment, but this is actually a photo of Tennessee's execution chamber. Tennessee was one of the few states during the time that I was practicing there that brought back the electric chair if there were not drugs available to carry out an execution. So that's why you have both an electric chair and a gurney for lethal injection. So in practice, as I was navigating post-conviction relief for my death sentenced clients, those of you that do practice post-conviction work, particularly capital work, you know that the vast majority of the claims that you raise really fit under one single umbrella, which is essentially ineffective assistance of counsel. So it's not just that the prosecutor used inflammatory prejudicial language, is that it was ineffective assistance of counsel because counsel failed to object to the prosecutor's language. And so you're always trying to fit your claims in under the umbrella of IAC. And Nancy King, who's at Vanderbilt Law, I want to say in the early 2000s, the early aughts, wrote a fantastic research paper on federal habeas and the rates sort of claims that appear in federal habeas petitions, and found that 81% of them that are challenging state death sentences in federal court contain ineffective assistance of counsel claims. I found it to be a really inefficient sort of downstream intervention, raising IAC in post-conviction. It's a huge lift. It's very difficult to secure relief because of the second half of the requirement, which is prejudice. So it's like, counsel acted deficiently. That's often something that petitioners can show, but then attached to that deficient performance, were they able to prove prejudice, that there was a reasonable probability, a likelihood that the outcome of the trial, the outcome of the death sentence would have been different because of that deficient performance. So it was frustrating working on these cases in federal habeas, knowing that there were constitutional violations that my client had encountered, and a really hard road to hoe in terms of securing relief for them in federal habeas. And I thought, well, what else could perhaps could remedy this? And I thought about, maybe an upstream sort of intervention earlier on in the process, because what I found was so much of the ineffective assistance of counsel claims that we raised, that my team raised, doing all of the investigation and the research, is that a lot of it was about a fundamental breakdown in communication. It was poor relationship development. The lawyers didn't know what they didn't know about the client, how to approach them. And so much of it had to do with this breakdown in just the relationship formation in terms of differences between defense counsel primarily, not necessarily everyone on the defense team, but defense counsel primarily, and the client, because they came from such different backgrounds, and not even necessarily race and ethnicity, but income. And I think a lot, in Tennessee, you've got the four major sort of cities: Memphis, Nashville, Knoxville, Chattanooga. There are 92 counties. There were a lot of people that live in rural communities, and that's not necessarily where all the lawyers came from. And there was just this real relational divide. And so I was just, all of these ideas were sort of percolating in my mind. And so in this paper, I write about propose an intervention upstream that might address some of these barriers in communication, the breakdown in the relationship. And so my proposal is really to extend the Sixth Amendment right to counsel of choice to all indigent defendants. So all low-income people that qualify for court-appointed counsel. And I argue that this would allow basically all defendants, then not just defendants with means, but people that are low income, to choose counsel and to choose whom they believe. So it's from their perspective who would best represent them. And my argument, where most of my focus in this paper is that such an expansion could be of particular benefit to Black indigent defendants. So to be clear, I'm not saying that just, Black people should be able to pick Black lawyers. As you've read, not all Black people want Black lawyers, for a variety of reasons. But this is where I wanted my focus to be in. So what if then we look at a Black indigent defendant who may prioritize sort of this relationship development and racial congruency? Then what happens? Let's talk about that. So I have a big picture intervention, but my focus is really in a narrow sort of area. And what I found in poking around at the right to counsel of choice is that folks have written about this. There's a very long footnote. The law review editors at NYU were like, Professor Hoag, you don't need to put all that information in the footnote. And so a subsequent draft of this will probably be a little bit leaner on the footnotes. But I think, particularly for young academics, we want to show I have support for everything that I say. And so I know at least I have a tendency to over footnote, but I'm going to try and streamline that in a future draft. But in that long footnote that talks about all the other scholars that have written and thought about, contemplated the right to counsel of choice, we see all these different theories, right? So there's the free market theory, there's a comparison of what the British do, which is sort of like a voucher system, that anyone can, low-income people could basically use a voucher and then use it to hire someone, hire with your voucher, even like sort of like a private sector attorney. Most folks say that, choice is good, both substantively, perceptively from the defendant's point of view, but no one really talks about communication and trust and how maybe race, ethnicity, background can impact choice and the attitudes about sort of relationship formation. And so I thought too about the demographics in practice. And this is something that was pretty clear to me as a practicing federal defender, is how essentially white the population of public defenders are. And that's very much a reflection of the legal profession. The legal profession is one of the least diverse professions in this country. I think maybe architecture is up there, is less diverse, but it's about 5% Black. The population in the United States is roughly 12 to 13% Black. Similarly low numbers for Latinx and Asian Americans, and quite low for Natives. Again, not reflective of the population in this country. And when we think about who is low income and in need of legal services, you have a disproportionately high number, particularly in the criminal legal system, of Black and Latinx defendants. And so that's another thing that I was toying with. So you've noted in the paper that I engaged in some qualitative research. This is a new arena for me. I was an American Studies major in college, and was really drawn to the research and methodology of sociologists. And so I wanted to talk to people. Unfortunately, when I was putting this together, I wanted to talk to people in the spring of 2020, and what was happening in the spring of 2020 was the COVID pandemic. So that really limited sort of my imagination, and I do want to revisit and maybe do a wider survey in the future. But I initially wanted to talk to indigent defendants, Black and Latinx, in particular Black, and ask them about their experience with their public defenders and whether or not they prioritized racial congruency. That was quite difficult in the midst of the pandemic. And so in navigating Columbia's IRB process, I narrowed it essentially to Black attorneys, Black public defenders. And I partnered with this relatively new organization, which is fantastic. Any other practitioners, academics out there, it's the Black Public Defender Association. It's under the umbrella of I think it's the National Criminal Defense Lawyers Association. And it's a great group of Black PDs and allies that really prioritize racial justice and public defense. And they've already issued, I know, a couple policy reports, particularly a report to Biden-Harris assessing their first 100 days, really encouraging the administration to dismantle and disrupt all of the carceral systems that our clients interact with, not just the criminal legal system. So little plug for BPDA. So I partnered with an organization and we issued a large survey. They had interest too, about their membership and their experiences in individual offices and training on sort of cultural competency, the numbers of Black people in offices. And so it was a good partnership because they wanted information, I wanted information. So I then followed up with people that filled out the survey. It was volitional. BPDA has a pretty large membership. and the survey spread out. And then I then followed up with some folks that filled out the survey and asked them if they would be willing to basically participate in a study. And this is all, those of you that have navigated IRB, this is the kind of thing that you do and say, oh, and you don't have to answer the questions. You can exit the survey. And so I ended up really interviewing just a handful of folks via Zoom. These were open-ended questions. I haven't really explored in the paper sort of the impact that me as a questioner, a Black woman who's a public defender, may have had on these interviews. But that's obviously part of it and is relevant. But I had these open-ended conversations with folks mostly about their perception of the impact of their race, the relevancy of their race in relation to Black clients, and how that impacted trust and communication. Some of these conversations were 20, 30 minutes, others were over an hour. This was also during the height of the demonstrations and unrest following George Floyd's murder. So folks were very willing to talk and had a lot of thoughts and a lot of thoughts about how race was not addressed within their office, and cultural competency was not addressed within their office. And the assumption, and I know others have written about this, Jonathan Rapin, at Gideon's Promise, and others, Song Richardson, about the fact that public defenders can harbor anti-Black bias. And there's always an assumption that as PDs, we don't carry bias because we are, defenders of the poor, and we tend to be more progressive and Democrats. But what we do know about implicit bias is that we all carry it, and so that's certainly true within public defenders. So this was an interesting time to do this kind of qualitative research. And I just felt really fortunate for the folks that agreed. Mention a little bit of the stats on the legal profession. This is generally not just public defenders. I know I do have some data within the article specifically about public defenders. There's great data on federal defenders, not as great data on state defenders. And then looking at the makeup of our client population in state court, again, people of color overrepresented. There are a number of states where the incarcerated population is more than half Black. So I've noted that. I think this is where I wanted to perhaps stop the share momentarily, get back to the big screen. I don't know if there are questions yet, but I wanted to give a little bit of information about some of my caveats in doing this research, and then I'll jump back into the slides. So if you do have questions, this would be a good time. I see there's 2 things in the chats. Thank you for clarifying on the National Legal Aid and Defender Association. I appreciate that. Great, thank you. Okay, so, as a threshold matter, my arguments, they don't assume that Black people are monolithic. I think that's important to put out there. Differences in class, in gender, sexual orientation, educational level, these are some of the many factors that can impact a Black person's identity formation, and then in the ways that we relate to other people, all of this relevant in the attorney-client relationship formation. And so my proposal, I want to make clear that it doesn't assume that all Black indigent defendants would want a Black lawyer. But what I wanted to make clear, and I hope you all gather this, is that there's a shared social meaning in this country in particular attached to being Black. And it's one that creates this unified understanding, shared reference points, similar experiences that can, not always, but they can transcend class, gender, and nationality. And given the nation's history of slavery and the resulting racial hierarchy, those of you that have read Isabel Wilkerson's Caste, it's a great example of it. Society assigns a presumption of dangerousness and criminality to Black people. And that's something that as a Black person in this country, we all encounter. We may have experienced it, and we certainly have witnessed it. And so this presumption is the shorthand that we know that law enforcement officials often rely on in fatal encounters with Black people, and what the criminal legal system assumes when determining who to charge, what charges to file, whether to convict, and then judges when determining the length of the sentence. All of this is part of a consideration when the defendant is Black. It's part of a consideration that is not often officially addressed, in filings and in court. But the research we know shows that this presumption is what informs how much time a defense attorney spends on a case. We know this from Song Richardson and Phil Goff, and where to start and end plea negotiations. Vanessa Atkins has done some fantastic research in this arena on pleas. And the presumption is also what fuels the criminal legal system and demands, I argue, changing the delivery of indigent defense services. So I want to pop back into the slide that I had that goes through Powell versus Alabama. So many of us know about Powell versus Alabama. It was decided in 1932 as one of the 3 U.S. Supreme Court cases that resulted from the Scottsboro Boys saga, which were 9 boys. They ranged in age from, I think it was 13 to 19, charged with scant evidence of raping 2 white women on a train that was traveling from Tennessee to Alabama. And they were all wrongfully convicted. All but the youngest, who was 13, were sentenced to death in these trials that could be referred to as a trial in name only. So very quick proceedings, all white juries convicted and sentenced them to death. But it's from this case that we get not just the right to counsel when a defendant is facing a capital charge, but we get the right to counsel of choice. And so Powell, as I talk about in the historical portion of the proposal, was part of this wave of cases that the Hughes Court decided in the 1930s. And it helped shape modern criminal procedure, what we know as modern criminal procedure today. And these were cases where the court, this was the US Supreme Court, overturned state convictions and death sentences due to the denial of the defendant's constitutional rights. This is not an unfamiliar concept to us now in 2021. This was new and novel at the time. And so it was really the Hughes Court that was active in this arena. And these cases, they were almost exclusively involved indigent Black defendants and blatant injustice in the South, and they were nearly identical in nature. And so you had Black suspects, like the young men, the boys in the Powell case, that were charged with the rape and or murder of usually white victims. And there was a threat of lynching. And as a result, we had these swift proceedings. And so it was sort of this appearance of due process, moving extrajudicial lynching into the courthouse. And so at the time, the Southern Bar, with very few exceptions, was unwilling to provide quality representation to poor Black people, particularly those charged with capital crimes. Violent white supremacy, the threat of social ostracization prevented even well-meaning white lawyers from providing zealous defense. And there were few schools in the 1930s that were graduating Black lawyers. Howard Law single-handedly supplied much of the nation with Black lawyers at the time. And when Powell was decided, there were only 4 Black attorneys practicing in Alabama. So, as the U.S. Commission on Civil Rights later reported, so this is a report that came out in the 60s, this was by no means exclusively a Southern problem. So, I argue for a poor Black defendant, the ability to choose your own lawyer could have made the difference between life or death. The court mentions that the boys did not have a friend. There was no friendly face to advocate for them in court. And it was from this context then that the court recognizes not just the right to counsel, but the right to counsel of choice, later referring to it as part of the root meaning of the Sixth Amendment. This was certainly not something I encountered while I was in law school and talked very little about it, if at all, in practice. And the right to counsel of choice enables a defendant to select the lawyer that they believe would best represent them. Of course, subsequently, the court limited this right by time, the need for judicial efficiency, and also money. So only defendants with means now can exercise this right. So I argue that there are some potential benefits to racial congruency and representation. This is what I get to towards the end of the paper. And I argue, that this is an under-theorized area of law under theorized area of practice. And so it could all use, and I'm speaking to all of you on this call and all of you that will view this video later, to engage in this sort of research, this qualitative research. But some of the benefits that I argue is that it can help with trust and communication. I collected some of the qualitative research in which, lawyers said, I witnessed the client's shoulders drop. I don't know, but I felt like they were, told me about family members to talk to. They wanted me to reach out to their mother because they trusted that I would follow up with that communication. And it wasn't always something explicit and tangible that the Black lawyer that I spoke to could hang on to, but it was a sense that they had. And there were some anecdotes about comparison. I had one attorney tell me that she was the only Black attorney in her office, and she on occasion had colleagues, white colleagues, who were representing Black clients that would ask her to essentially serve as a translator. So they were having trouble communicating with the client about a plea offer and whether or not to take that plea. And they called her in to say, could you just talk to my client? She didn't tell the client anything different, but somehow that racial congruency allowed the client to trust what that lawyer had to say about the plea offer, and then was able to accept those terms. I also gathered information about just having a Black face as a defender in a room put some of the clients at ease. And again, this is the perception of the lawyers that I'm speaking to. I didn't get a chance to speak to defendants in this IRB setup and process. I argue, and this leans heavily on my experience as a capital post-conviction attorney, that it can help in terms of developing and presenting mitigation evidence. So this idea of having familiarity, cultural competence, knowing how to identify, seek out, and develop avenues of research. The late Charlotte Holdman writes about this extensively in the capital mitigation investigation context, that you must have someone who is culturally competent, not always same race, but culturally competent, has the awareness of the impact of their own race and ethnicity, has an awareness of the client's background, doesn't necessarily filter through the information that the client's giving them through their own culture and background. That can help open up those lines of investigation. And then interestingly, one of the defenders that I spoke to said, my same race, the racial congruency between me and the client, helped shape a theory of defense. She had been brought on by two white lawyers to join the team. They were having trouble connecting with the clients, singular. And once she joined the team, she was able to forge a connection with the client, who then was able to suggest other areas of approaching the case, of putting forth a defense that didn't come up with just the other two lawyers. And so this was part of her perception, again, that I'm collecting and then using in the paper. Those of you also that practice in California or just know Brennan Woods, this is a photo of the chief defender in Alameda County. And then based on the research that exists about defense counsel and bias, we know where racial congruency and cultural competency might help. So I mentioned already, Song Richardson and Phil Goff have written about the implicit bias in the public defender triage. That implicit bias can activate, most especially when public defenders, as we all are, have a lot on our plate and are rushed, and so we're triaging. Which client do we spend the most time on? Which client do we put our time and effort and resources in a given day when we've got, a caseload of 80, 100 clients? I know those of you that practice in state court, this is part of your reality. And given implicit bias can trigger during this sort of triage process, Richardson and Goff say that it impacts the amount of time and effort that a defender will spend on a client's case and with a client. I've already mentioned Vanessa's research with the plea negotiations, so it impacts there. And then Nicole Gonzalez Van Cleve has that great book on Cook County, Illinois, but talks about sort of development of evidence in a case where there's a sort of cultural background mismatch. The client mentions a friend's nickname who's a witness, and the defender doesn't follow up because the client doesn't know that person's given name, just knows sort of their street name, their nickname. And then I do a comparison in terms of therapy and the education context, like primary K through 12 education, about the benefits of racial congruency. And so in the education context, they talk about both the passive and the active effect. So sometimes for students, racial congruency has a beneficial impact on students, but it's just sort of measured passively. So it's that a Black teacher can serve as somewhat of a role model and as a positive image for a Black student to witness on a daily basis, and that can be an impact. And then the active impact is more so that the racially congruent teacher spends more time with the student, doesn't necessarily see subjective misconduct the same way that perhaps a non-Black educator would look at, and doesn't necessarily refer that student to the principal's office, or refer that student, as more often happens, to the juvenile justice system. And so I took that sort of framework and put it into my ideas about racial congruency in public defense to say that there could be both a passive effect. Having a Black lawyer in court may make the prosecutor think twice about whether or not to remove, a person of color from a jury, or make the judge think twice about asking, the prosecutor about what is their race neutral reason, for removing a juror in the face of a Batson challenge. These are untested sort of areas of research, and so this is just me posing sort of a hypothetical based on this framework that I know about from the education context. I think that is the end of my prepared remarks. I was thrilled when Andy reached out to me to give this presentation, to share my work and my research, and I look forward to questions, suggestions. This is definitely informing my research going forward. I'm working now on an article about developing cultural competency, and how in law schools we need to be doing a better job about that, looking at what happens in the medical school context, where you are required, the bodies that oversee medical school curriculum require medical students to learn about cultural competency, given how diverse their client population is. And that's something similar doesn't exist in the law school context. And so many of us can go through law school, so many of our students can go through law school without contemplating how it is to interact with clients, or even have sort of a client interaction, particularly looking at, our first year curriculum, which is so steeped in doctrine and not necessarily in, hey, we're in this service-oriented profession, how do you go about delivering that service? So I will stop sharing because I can ramble, but I'm just so grateful to be in conversation with you also. So thank you.
Thank you so much, Professor Hoag. We're so grateful to have you here. Truly, this is such good stuff. We have about 40 people in the room right now. I would like to simply, there's usually a moment of awkward silence where folks wait if they should be the first. Stephen, I see you've raised your hand. Perhaps we'll do it this way. Can I ask you to unmute and ask your question, please?
Oops, there it goes. Hello, can you hear me? Everything good?
I can. Hi, Stephen.
Hi. Thank you so much for being here. It's really fascinating research, and I'm really interested in, especially within the last year, how public defender offices are grappling with the challenges of staffing in a way that represents the people that we serve, and other changes sort of structurally and policy-wise that we can make to do that. So one thing that I'm just curious about is, only anecdotally, I have heard from colleagues a concern that Black defenders, young Black defenders in the offices I've worked in, so they don't have a lot of role models, they have a lot of pressure, it's like very, very hard. But another thing that does happen is caseloads are higher for those folks. And so that's a thing that keeps popping into my head, is if we let people choose their counsel and people maybe gravitate towards people who share their culture, their values, look like them, whatever it is, and then, what effect might that have on like caseloads? And of course, staffing then has to be beefed up to make sure more people are included. But just any thoughts you have on that, something to think about.
Yeah, Stephen, thank you for that. And that was definitely a sentiment that I heard in the interviews, and particularly with the anecdote I shared about the woman who was the one Black lawyer in her office and being called in as his translator. And she said, I don't mind doing it, but I also don't know the evidence in the case. I don't know the other issues. And I'm being spread really thin, and the jurisdiction in which she practices in is almost exclusively Black. And I talked to a state post-conviction attorney who was the only Black post-conviction attorney in the state. They had 27 post-conviction attorneys, and the client population in post-conviction is 70% Black. And so she was spread quite thin, and also didn't necessarily have support for the arguments that she wanted to raise in her cases. Sort of felt like she was like junior mid-level-ish, and just felt like she was going out on a limb in some of her cases, and didn't feel comfortable with her colleagues telling them, you should really look into these certain issues. These are record-based appeals, but you might want to explore this avenue. So I anecdotally, again, through my limited qualitative research, picked up on that same theme. And something that I explore very, very briefly in the paper is this idea of like a Black tax. And Black academics experience this in law schools, is that, a lot of the students of color, progressive students, depending on your sort of own practice background, if you have one, will attach on, this certainly happened to me at Columbia Law School. I adored all of my students, but I'm like, wow, how do I research and teach when I have all of these students coming to me to sort of navigate the issues that all of our students and young lawyers encounter in practice and in school. So that is a concern. And the solution is that we are prioritizing cultural competency with our whole staff. And this isn't just about race, but I think too about the primarily, not exclusively, but like privileged background that a lot of lawyers come from. And even if we didn't come from a privileged background, we're a lawyer now. And that can create a gulf and a divide with our low income clients, which that's what we have. They're indigent. They need a court appointed lawyer. And so navigating that cultural divide. So I think it's something that I haven't seen in a lot of offices prior to us. I think things are changing, Stephen, as you say, particularly this last year. But I think offices and now law schools are realizing like we are way behind the curve on this. So thank you. I'm very much on the same page.
I really appreciate it. One of my really key interest areas is in how process and policy lead to the goals that you're trying to achieve. And so especially things like case assignment process and case caps, case loads and stuff like that can really have an impact on these kinds of issues. So I'm very interested to hear your thoughts. Certainly, I think training and things like that, as you mentioned, cultural competency are big themes. So I appreciate your thoughts a lot. Thank you.
Thank you.
Thank you, Stephen. Michelle Hall, you're next.
Hi, thank you so much for presenting. So my question, I practice in Prince George's County, Maryland, which I loved your statistic about Maryland having 72% of people in our prisons and jails are Black. But I wonder if, I know you spoke a little bit about offices where there's only one or just very few Black defenders, and I wonder if you saw any difference or explored offices where there are more Black defenders. I know in Prince George's, it's not that we are the majority, but there certainly are a lot more than I think the traditional office. And then I also would be curious your thoughts on this passive impact of having a Black defender in counties and jurisdictions where there are more Black actors. And I think anecdotally, my experience has been that because so often prosecutors are Black, judges are Black, that when we're raising these issues of race, whether explicitly or implicitly, it is read differently because all of these actors in here are Black, which is kind of getting into like locking up our own territory. But yeah, so those 2 points.
Yeah, Michelle, thank you. You raised so many good points. I try not to reveal the states where the defenders that I spoke to are from, particularly when I say like, oh, this defender, with natural hair, if I give the state, it's almost like obvious, like what federal defender office she's from. And so I was trying not to say too much about Maryland, but that was a state that the statistics were so jarring in terms of the client population. Pennsylvania is similarly situated, as is Louisiana, with just really, really large Black populations incarcerated relative to the state population. So you raised so many good points in that. The passive effect, it's really different, right? When all the faces in the room are Black. We explore this we scholars, researchers explore the impact of Black police officers of color, and can that maybe decrease levels of violence with Black and Latinx suspects, people that they encounter. And it's not necessarily because the overriding culture of policing. And I think there's some research that says if you have sort of a critical mass of Black people, then the contacts of violence go down. It's like 40%. But I think Baltimore's police department is almost over, mostly Black, and that police department in particular has had a lot of issues with lethal encounters with individuals. And so it's not such a cut and dry issue in the racialized criminal legal system that we operate in. And Nicole Gonzalez Van Cleve has great she's a sociologist, a great research in that area, that you walk into a Cook County courtroom and you've got Black court officers, you've got Black judges, you've got Black DAs, and there's a lot of implicit and explicit racial discrimination going on because of the way that our criminal legal system operates. And so I think it's harder when you've got all the faces in the room that are Black, and you're still seeing this discriminatory weight of the court on your client. And I'm so glad you brought up Foreman's Locking Up Our Own. I think what was so interesting about some of his research and what he explores with the increase in incarceration and prosecution is that there are leaders in Black communities. This is coming off of the civil rights movement, where we start to get more Black mayors and police chiefs and prosecutors. And in terms of getting funding from the government, it was often filtered through tough on crime. And so if you were going to get money in your community, it was basically to prosecute more people and to lock up more people, but it was still money. And so that's very much part of what Foreman is talking about. I don't have a clear answer for you, obviously, Michelle, but I'm just so grateful for the issues that you brought up. And these are issues that I'm also interested in exploring.
Thank you. Thank you.
Thank you so much, Michelle. We have Janet Moore up next.
Hi.
Hi, Janet.
Hi, it's delightful to meet you and to see all these wonderful IDRA people. Hi, IDRA. Tremendously exciting project, and a really, as you know, such an important contribution to the council choice literature. So, amen, yay.
Oh, thank you.
Bravissima. My only kind of quibble is toward the end, you're talking about the Comal County experiment. Mm-hmm. And relying on the report that was issued and then a law review article about that report. There, in my opinion, and I've done a little writing on this, there's reason to be somewhat circumspect about the conclusions there. And I can shoot you a copy of the article if that would be of interest. The reason I mention that is because this is so fabulous how you are merging the empirical and the law fields, right? And so as we're doing this work, I just think we want to take into account the different pressures that are on the systems that can shape the quality of the empirical work that's done. And I think that's what happened with the Comal study. Best intentions, but a little worrisome in terms of what they really have to substantiate their claims.
Yeah, Janet, thank you so much for the kind words, and then also the words of caution. So the Comal County pilot program was really inspired by Stephen Schulhofer and Friedman's work and their suggestion on what the extending the right to counsel of choice could do for low-income clients. And so Comal County is a jurisdiction, it's small, and it's one where the court relies on sort of a collection of court-appointed attorneys. It's not a community that has an institutional defender office like you would find in San Francisco, New York, other larger jurisdictions. And they allowed some clients to have essentially choice. So it was like I think they got lists of attorney names, and they could pick out who would represent them. And there was a study and evaluation done of that pilot program. And there, as Janet mentioned, there's some cautioned hesitation about how much we can rely on their findings because they had such small numbers. And so I very much appreciate that word of caution. And I think, in the footnotes, in the way that I talk about not just the study, but the evaluation of, the program, to be clear about how small the sample size that they studied was, and that we can only rely, so much on their findings, given that. Thank you for that link. Other questions, thoughts, reactions? I know I mentioned in the paper that, the reality that not every Black client would necessarily want a Black lawyer. I had a conversation with a defender that said, as soon as the client saw him, shouted, I want basically someone else. I want a white person. I want a Jew specifically, is what the defendant had said. And, there's a few takeaways that we can have from that. So, our clients are part of the social fabric of this world, and may have ideas about who could best represent them, in court, because of the institutional racism they experience and see. And, I talked to lawyers that talked about sort of their assumptions that other sort of court officials have when they enter sort of a courtroom. They're mistaken, for someone who's just not basically the lawyer. And that, our clients aren't blind to that. They see the way that Black lawyers can be treated in the courtroom space. And then it could be also, internalized racism, that they don't believe perhaps that a Black lawyer would operate as competently. And so there's a number of things going on there, but these are all issues that I didn't want to shy away from because they exist in practice. And this is not necessarily, an imperfect intervention, but it's one that I definitely wanted to give airspace to, mental space to, and encourage jurisdictions of varying sizes to explore and consider, like what could happen if we extended choice. And I also think about some of the remedies that are possible for clients, appealing their convictions and sentences. And when you're stuck with just IAC, it's such a hard road to navigate, particularly with procedural default that happens as we get into state collateral review and federal habeas. And so this idea of elevating the denial of the right to counsel of choice to perhaps like structural error. And so what is the remedy in structural error? You don't have to prove prejudice, and you get a new trial if there's essentially like a denial of counsel. And so I was also thinking about what this could do for clients navigating remedies in post-conviction. I can go on lots of tangents if you give me the space. Please, if
thanks, Professor.
Yeah,
we do. So I got a message from Nate Fennell indicating that he wanted to ask a question.
Hi, yeah, I'd be interested to hear your thoughts on sort of, particularly for people that request an appointed lawyer and are in jail, thoughts on sort of what information we might provide to people if they had choice of counsel, sort of how we make people actually able to use that in a meaningful way, right? Like we sort of already mentioned the list in Comal County as maybe being inadequate, but sort of how, do you have a vision on how we would actually make that, let people exercise that right effectively?
Yeah, Nathan, thank you. Implementation. I don't give a lot of page space to implementation because it's a thorny issue, and particularly given like sizes of jurisdictions. How do you present choice to a client who's about to be arraigned and doesn't have a lot of time to evaluate information? And so do we give, a list with photos, background information? This is someone who specializes, in sort of assault cases, or specializes in, felon in possession, in common charge in federal court. How do we present those ideas? And I don't give a lot of details on it because I don't have all the answers. And I think it would vary so drastically from jurisdiction to jurisdiction. I think about New York City. So I went to law school in New York and spent a lot of time in clinic. And, I spent time at Bronx Defenders, Neighborhood Defender Service of Harlem, and Legal Aid Society. And that doesn't even name all of the defender providers in New York. And so how then do you communicate, to a client? Do you want an 18B? That's like the conflict sort of attorneys. Do you want someone from Bronx Defenders? Do you want someone from Legal Aid Bronx? And admittedly, it is harder in a larger jurisdiction. But I think in some of the smaller ones, this idea of like, there could be a finite list of attorneys, their areas of practice, and perhaps their photo. And this idea too of choice, it's, not every Black indigent client would want a Black lawyer. They may not prioritize racial congruency. That may not be their primary concern. And because I didn't get to collect sort of clients' perspectives, that wasn't an area that I could really explore. But yeah, it's Como County was sort of an ideal petri dish because it was so small and didn't have institutional defenders. So that was my non-answer answer.
Yeah, I get, just to briefly follow up, I don't remember, I apologize if this was addressed more thoroughly, but within the concept is among a public defender, within a public defender's office or elsewhere, right? I guess like I had originally, because I work in Texas, been thinking about this in places that just have a list.
Yes.
That's how everything is. But your vision is like even within the public defender's office, like you pick which of the full-time public defenders you want versus like, is that?
Yeah, I thought about it in both scenarios. That, and here at Bronx Defenders, here's their list of lawyers. What was interesting about Como County, and I'm sure Janet also encountered this, is that sort of who to pick as a lawyer traveled via word of mouth. So you had a lot of folks that had repeat contact with the criminal legal system and experience like, Nathan's the attorney you want to get. Like, go ask for Nathan in lockup. Or, David Fletcher is who you want. Ask for David Fletcher. And so, the concern then, which I know came up in another question, is like, what then if everyone's asking for Nathan and David? No one's asking for Janet. So there has to be some kind of caseload sort of equalization if someone's bombarded with clients who routinely pick them. And then I also don't want to set up a situation in which I'm perpetuating some of the discrimination that happens in practice. So people have assumptions that female attorneys aren't going to be as capable and competent for them. And so they're not asking for female attorneys. Or because of internalized racism, or they think that, Black lawyers encounter the same kind of racism I encounter, so I don't want to pick a Black lawyer. And then you have sort of really lopsided caseloads there. I mean, these are all issues I don't want to ignore, but could happen, if we were to democratize choice. I see Rosalie has her hand up.
Yes, thank you, Nate. Rosalie, thank you also. We've got about 3 minutes, so you're probably going to be the last one.
Okay, just really quickly, one other aspect of client choice. As a former public defender chief who was looking to motivate staff to perform to their best, I thought, wow, what if, two of my staff are always getting the requests to be their lawyer, and how that could actually change the dynamic of who works the hardest and how that all plays out.
Rosalie, thank you. And that's, so the existing scholarship on counsel of choice talks about that very issue, that in a free market sort of reality in terms of counsel of choice, you would actually, it would prioritize lawyers to sort of perform better in sort of whatever areas they note the choice is happening in. And I thought too about, if clients really do want a more diverse collection of lawyers that have cultural competency, if that's what they're prioritizing, then defender office need to prioritize those things in their hiring and their training and their promoting. And so there could be a quality improvement if we do institute choice, and that's where the demand is coming from. And so I think, there are a lot of these caveats and concerns and limitations that we've been discussing, but Rosalie, your point in particular is one that I think really encourages, choice, to democratize choice for that very reason. So thank you.
Thank you so much. I hate to cut this off. This is my least favorite part of this, but it's always good to. I myself have questions that I'm going to hold on to, but we do like to be respectful of people's time, and we love to leave it at just to the point when people are sort of craving more. So Professor Hoag, thank you so much for sharing your work with us, and thank you so much for taking the time, particularly after your long flight, to present to us and to answer our questions. We really, really appreciate it. It's great work. Clearly, you've excited some energy in the room. There are other people who are really engaging in closely related projects. Maybe they'll be in touch further. I hope so. But yes, thank you again, and we really do look forward to being in touch.
Yeah, it's been a real pleasure. I see so many familiar names from my former colleagues from the FPD office. So I'm just grateful to have the platform. And please do follow up with me via email. You can find me on Twitter, alexis.hoag@brooklaw.edu. I would love to continue this conversation with scholars, with practitioners, folks interested. And my research sort of agenda is very much within the Sixth Amendment right to counsel. And so I'm going to be exploring this area for some time. So thank you.
All right, we all came to the right place in that case. All right, thanks so much. We'll let you get to your second cup of coffee, and thank you to everybody for being here.
Thank you.